reduced this payment what they have received. Now we have said so, and they protest this 20 persons who says before the court, and this payment that has been received, now they have to say no. They have to say now. Honorable arbitrator has only taken the fact that no agreement has been entered. The mode when we come now, Rule 9 exhaustively prescribes. If your leadership may have a look at the rule itself prescribes. If I just place Rule 9(3), and the competent authority is notified by the central government. Absolutely, there is no dispute about that. The competent authority had offered that we receive the payment. Rule 9(3). That will be at page 16. 16 of this book. So, the rule starts from page 14. Yes. Rule 9(3). Rule 9 is compensation. And Rule 9(3) says the competent authority shall, as soon as may be practicable after the making of requisition order or the service of a notice of acquisition, communicate to each person interested an offer of what, in the opinion of the competent authority, is fair amount of compensation payable to such person in respect of the property requisition or acquired. If the owner of the property is not readily traceable, or if there is no person competent to alienate the property, or ownership of the property is in dispute, I skip merit for this purpose. For present case, it won't be relevant. Then I, every person interested to whom an offer is made under sub-rule, within 15 days, leadership may take note of receipt of the offer, communicate in writing to the competent authority his acceptance or the revise of the offer. If he accepts the offer, the competent authority shall enter into an agreement with him on behalf of the central government in form. In the following circumstances, the competent authority may, at his discretion, make all eligible claimant on account payment of 80% of the amount, which in his opinion is likely to be assessed as compensation. So our case, relying on that judgment, that I offered, you received the compensation.
You have not received the entire compensation. Have they received the entire compensation?
80% is earmarked in the Exhibit 10. Now my point is that, by conduct, they have received it and they have not raised it in protest.
But 20% is still to be paid.
Yes, 20% is to be paid, and that is to be paid.
Did you pay this 80% to all of them?
Yes.
All of them, irrespective of the objector.
We pay objector value. That
suppose you say that the payment of compensation was taken to a logical end. Then why didn't you disburse the remaining 20%? Why didn't you disburse the remaining 20%?
We say 80% of the land uses. On instruction, I am saying not 80% of the compensation, not 80%.
80% of compensation. This
rule says.
This rule says.
But 80%. We have paid 80% of the land user. That is
how
the award.
From where you say?
From award itself. If I just take.
You complete reading this file.
Yes.
In the following circumstances.
Every person interested in the offer is going to writing. If he accepts the offer, in the following circumstances, the competent authority at his discretion make to all eligible claimant on account payment at 80% on account, in his opinion, is likely to be assessed compensation or recurring compensation as the case may be. When there is likely to be a delay in assessing compensation, where the competent authority has made assessment, but there is delay in reaching an agreement, though there is a reasonable prospect of agreement being reached, where it is clear that an agreement cannot be reached, if the competent authority makes an on-account payment under clause 2, he shall enter into agreement with persons to whom payment has been made in form L with such notification as the nature of his requirement. If the person to whom offer is made under Sub Rule 3 does not accept the offer, or does not within 15 days of the receipt of the offer communicate in writing to the competent authority his acceptance or otherwise of the offer, the competent authority shall, as soon as may be, submit to the central government a report setting forth the full facts of the case, particularly as regard to the nature and extent of disagreement between himself on one hand and the said persons on the other hand, and he shall also forward with the report all connected papers. The competent authority shall, at the time of deposit, in quote, the amount offered by him to the said person under subject 3.
So you are also supposed to deposit the balance amount.
Yes.
Did you deposit?
That your worship, I am instead of fixed because I was of the understanding that my instructing council is having all the exhibit, but I could find that none of the exhibit 10 yesterday I visited from the record, and I see that the payment is accepted without protest. That is exhibit 10.
Entire payment or part payment?
80% is reflected in
So
it.
80%.
So 20% I presume.
See, the point is, what is the format of the agreement?
That is Form K.
Let us see Form K.
Yes.
You see, this Form K is of great relevance.
Yes, yes.
The legislature were conscious of the fact that somebody might register protest, might not register protest, 80% being paid. Right? This particular form, clearly it is not a normal agreement. It takes away the right of the claimant to claim any further compensation. This is a statutory requirement which you should have entered immediately, and upon entry you should have paid the remaining amount. But you did not do so. The matter lingered. So therefore payment of 80%, I can see if there is payment of 100%, then we can think of something. But when there is a payment of only 80% and the agreement, statutory agreement having not been entered, you cannot say that they have no right, and they have accepted the amount without any protest. This acceptance of amount without any protest is followed by an agreement in writing. You just have a look at this.
So this deeming, the judgment which I pressed before the worship, this is of there, but it says that when you accept it, then it will be deemed that you have accepted the offer.
Without Form K. No, you just have a look. We will see that. You see, the entire judgment and entire facts of the case is not in that one paragraph.
No, it's not.
It's not there.
What I am trying to converse, Mallet, Form K is not entered. Let us be very
You
clear.
just read this Form K.
Yes. I have gone through memorandum of agreement. So
This
if before reading Form K, Mallet, if I read
see, after quantification of compensation,
yes,
and before the entire amount is released to the claimant, the legislature has taken a precautionary measure that if a person, the entire compensation, the remaining 20% will also be disbursed after one person enters into Form K, and the clauses of the Form K is very, very clear that no further compensation will be paid. That is as good as settlement brought in writing.
that is what it says.
This is what it is.
But what I am putting forward my case. My case is that suppose I don't pay 20%, I am not paid. Let us assume that 80% is paid, 20% is not. Then what right you accept it without protest? What right then survives is interest on 20%. It will not give a right that you have accepted 80% under protest. This cannot be read into it. This is my humble submission.
No, I couldn't
Your
get
leadership.
it.
For your leadership's kind consideration.
No, I couldn't get it what you said.
I say that once 80% is that is my offer. I come with my offer that this is the amount. Suppose 100 rupees I have to pay.
Okay.
I pay you 80 rupees. You receive it because the figure is before you.
That's right.
And I have given 80% of that figure. Now that then you don't receive it without protest. I hold 20% of it. That does not mean that there is a protest from your end while receiving 80%. My offer, the word that is used in rule is offer. The word that is used in the act is agreement.
We will read absence of protest. We will not read absence of protest without form.
Once again,
if you want to read absence of protest,
yes,
then you have to show form.
Form
Because
K,
that is the statutory method of closing the scope of the test. Merely because a person has received the amount and has not mentioned under protest, that will not non-suit them.
if I take
You want to say that irrespective of Form K, it should be irrespective of Form K, it should be accepted that the amount has been received without protest and there are no grievance so far as the quantum of compensation is concerned.
if I just place in my own way, I say that Form K is an outcome of consensus ad idem on the point of determination of compensation. One, I say that when I offer it, in absence of Form K, that I will pay you 100 rupees. And you say, I am fine with it. You don't say that I am receiving under protest, I should get higher income. You receive.
Why did you pay 100%?
I am coming to that. So then that will be a case valid because Contract Act Section 7 never says that it should be in writing.
We will not, you see, when the law prescribes a particular thing in a particular manner, we will not say that Form K is optional. The court will not interpret Form K in a manner that it is optional.
No, it's not optional.
Then when did you enter Form K?
The Form K has to be read by the conduct of the parties also. That is what the judgment, and one judgment if I just place for the issue, that is 95 supplementary 4 SCC 660. Yes. Citation number. 95 supplementary 4 SCC 660. See? 60. Coming to para 5.
Yes.
Next present. Reading of this rule does not indicate that after the award has been made, the competent authority is enjoined to communicate its offer in writing to the person interested. Such interested person is also enjoined, emphasized by the use of the word shall, to communicate within 15 days of the receipt of the offer in writing to the competent authority the acceptance or otherwise of the offer. If he accepts the offer, the competent authority is further enjoined to enter into agreement on behalf of the central government with him in Form K and pay compensation. If the interested person does not accept the offer nor communicate within 15 days of the receipt of the offer in writing to the competent authority his acceptance or otherwise of the offer, the competent authority is enjoined to submit the central government a report setting forth the full fact, in particular the nature and extent of this agreement between himself and the interested person, and should forward with the report all concerned papers to the government. He is also enjoined to deposit in the court the amount offered by him to the interested person. Thus, it may be seen that the interested person is enjoined to communicate within 15 days from the date of receipt of the acceptance or otherwise in writing the offer made by the competent authority. The ratio of Sito Devi versus Union of India, on which reliance was placed by the counsel for the respondents, has no application on the facts of the case. Therein, it was found that by the court that the fact of the case of the appellant is that they had accepted the amount sent under protest, to which there is no demur, and therefore they did not sign the agreement in Form A and was sent, which was sent to them. In those circumstances, the court had held that the competent authority and the central government ought to have appointed arbitrator to determine the compensation payable to the claimant. In this case, however, since admittedly the appellant had not communicated their acceptance or otherwise of the offer made by the competent authority, there was no duty cast on the arbitrator under 81B of the Act. In para 79 of the decision of Hari Krishna, this court considered the observation made by Arvind. What was stated in Hari Krishna's process cannot assist the respondent because the general ratio in the case is the provisions of the Land Acquisition Act have no application to the acquisition under the Act, and the payment of solution of interest cannot be sustained since the Act did not provide payment of interest solution. That is why the different is squarely covered. It squarely applies to the facts of this case for the reasons that there was no laches on the part of the appellant in appointing the arbitrator, which was assumed in Hari Krishna's case. So, should I further?
Yes.
We have said about there being no laches on the appointment of arbitrator in case at hand, as the obligation to appoint arbitrator arises where the interested person communicate his non-acceptance of offer enjoined by Sub-Rule 5.1 to Rule 9. The requirement of Sub-Rule 6 to submit a report to the central government that the person to whom offer has been made does not communicate within 15 days cannot be regarded as requiring central government to appoint arbitrator on knowing about the fact of non-communication of interested person. According to us, something more is needed to require appointment of arbitrator. The interested person must communicate about his non-acceptance of the offer, which was not done here in the case at hand. In Harishankar Khosla's case, the court had assumed laches on the part of the central government due to delay of 16 years in appointment of an arbitrator. We should not draw such presumption here, since the determination of the compulsion of is the subject matter of latest will be declined to go into the merits. However, the award of arbitrator awarding solution and so for 1 year from the date of taking possession thereafter till date of stands set aside. In other respect, we express no opinion. So our submission is that when we offered and they have accepted it and they have not communicated any objection, there was no occasion for us to appoint arbitrator and see the conduct. They have come forward for appointment of arbitrator only in 1991. Only in 1991. And then 20% comes at first instance. Then the list has been enhanced by
those persons who are taken under protest, they
came before.
So for them, for those 20 persons, you don't have any objection.
No, I will come on the point of solution for them. Why I will come? Because the point is that even they did not communicate to me, but they received under protest. So for them, at least we should have won. But they came before the court 16 years, so we cannot be fastened with the liability of solution and other ancillary which is not prescribed.
Why did you deposit the amount in the court?
So that instruction. I may probably have to take instruction whether it is deposited. I am not.
You will find it either from the records. We do not know where the money.
That is what I.
For last couple of days.
It has not been deposited.
For last couple of days,
Yes.
this query is being put.
Yes.
Where is the money?
I go down. I was told by
The land is with
your
you.
ladyship also appoint that he is through with the facts, so I am carrying and this impression when I visited the record wallet in this schedule I could
So
not.
I can tell you, so far, there is no dispute that the money was not deposited.
I go down. Your ladyship has seen the record.
And if you have anything contrary, you
I
tell
will.
us.
So let us presume that it has not been deposited.
Yes, it
So
has
what
not
will
been
be the
deposited.
consequences? If 20% is not deposited, what will be the consequences to that?
If you are taken that the amount was taken by them without any protest, then there is nothing to show as to why did you pay the remaining 20%?
So 20% will entitle them for interest. This will not
No,
be
no.
protest is
Just
positive
a
action.
moment. So why didn't you pay remaining 20%? And why didn't you send them Form K for signature? Because that is also an obligation cast upon you. That you have to.
So what?
And if they do not accept it, and if there is any problem, you will have to deposit the same in the court. Simple. You have not done anything thereafter.
So if I do deposit, in my humble submission, I'm always subject to correction from the other side. In my humble submission, this is understanding of my law, that if I don't pay 20%, the other act also prescribes that that has to be given effect in terms of interest. That will not create a positive because you don't raise objection is a positive waiver of your right. That act says in clear terms that you, and that is how Honorable Apex Court in para 5 and onwards has discussed this issue. That you don't raise an objection, you receive 80%, you go in silence, then you cannot come with a positive case that I have, even if I have not raised protest, non-payment of 20% will be taken into consideration as if there was a protest.
The interest has been given on the entire award or only on the remaining portion.
Remaining portion, enhancement, first query, 6,000 has gone to 47,000. That also I will coming that what is the basis of that computation. Then solation, that 30% has been added to it, and then it has been given interest. So that my point is that 9% interest and with supplementary award, initial 9%, then with supplementary award, post award 15%. That is also one issue. That supplementary award, how can it improve the once the court has passed award, arbitrator he becomes functus officio, and how supplementary award there is no contemplation under that. What will be supplementary award? He comes forward with giving 50% of the interest thereafter post award. So this addition merit Your Lordship is clear about it. So I am advancing my submission. Well, law at many a point of time and areas may remain grey and in silence. That has to be interpreted to serve the purpose of the act. So my submission on first that we offered them, they received it. Yes, we paid 80%, 20% was with us. At the best, it is the case of the Raya that they can get 20% with interest.
Read Rule 6 for a moment.
Rule 6. Repairs to requisition premises.
There is one more form N.
L says that yes. N is under 953. This form L is under 953. So your Ladyship, 953, just we recapitulate what it says. The competent authority shall, as soon as may be practicable after making requisition order or service of notice acquisition, communication to each person interested an offer of what, in the opinion of the competent authority, is fair amount of compensation payable to such person in respect of property requisition. Now form L says, form agreement made on behalf of the central government with owners.
If the competent authority makes an on-account payment
Yes.
under clause 2,
What in the rules?
and
This form or
you just read Roman 5 Roman 2 and 5 Roman 3.
of the rules 953.
Yes.
5 Roman 3.
Roman 2 and Roman.
Compensation for acquisition property other than agricultural land. Is it?
So
Shall
you read 5. You read 5 once again.
Yes.
Every
Person interested to whom an offer is made under sub rule within 15 days of the receipt of the offer, communicate in writing to the competent authority his acceptance or otherwise of the offer. If he accepts the offer, the competent authority shall enter into an agreement with him on behalf of central government. If the following circumstances of the competent authority may, at his discretion, make to all eligible claimant on account payment up to 80% of the amount which in his opinion is likely to be assessed as compensation or recurring compensation as the case may be, when there is likely to be delay in assessing compensation, where the competent authority has made an assessment, but there is a delay in reaching an agreement, though there is a reasonable prospect of agreement being reached, where it is clear that an agreement cannot be reached. If the competent authority makes an on-account payment under clause 2, he shall enter into agreement with the person to whom payment is made on behalf of central government in form and with such modification as the nature of the case may require.
So payment of 80%, the law does not say that initially you have to pay 80% and then form K is to be entered. The law says that you have to pay 100% and form K is to be entered, right?
Form K, yes, simultaneous.
100%
Yes.
and form K.
Yes.
So just simultaneous, right? And so far as payment of 80% is concerned, it is just on account payment. The moment on account payment is made, it means that it is not even final at your end.
We have
You have paid 80%.
my rate compensation is final. By tendering of 80%,
No, you see,
if I just read it,
if in the following circumstances, the competent authority may at his discretion make to all eligible claimant on account payment of 80%.
yes, so I
You
would
paid
do-
only on account, you paid only 80%. So
Of
that 80% of the compensation, whatever you have
Determined.
quantified, naturally that was subject to finalization.
which is final.
No. If it was final, you would have paid 100% and entered into form C.
C says my rate.
We can't
5-2C.
ignore 5-1.
5-2C.
We can't ignore 5-1. If it was 100%, if you and the claimant were consensus additive with respect to the quantum of compensation and that it has attained finality in all respect, then you would have paid 100% and form K would have been entered. And further your conduct is that you only offered them 80%.
Of the determined company, if I say my rate 5-2C, just for a moment, 5-2C.
Yes.
What will be the situation? Up to 80% of the amount which in his opinion, is likely to be assessed compensation or agreeing where it is clear that agreement cannot be reached.
Yes.
So,
So 80% is offered under these circumstances.
yes.
You
So,
offered him 80%, and you say that it is full and
so
final.
where is
now.
this further reads merit
Need
that
not be
5C.
there because this particular the very act of payment of 80% itself indicate that the compensation was not final, even at your end. Even at your end, it was not final.
That has to be looked into the exhibit when we
You see,
tender.
look into whatever it is.
That is our
But,
exhibit 10.
but this
This is
payment
not
of
the finding of the
80%,
arbitrator.
the payment of 80% is offerable to this only.
But I have.
It may be that the arbitrator has not written in so many
Yes.
words, but the point is that the arbitrator has taken into consideration that Form K was not entered.
Yes, very
So
well. But
Form
where is
K
the
is
finding
entered.
that
Form K
compensation?
is entered. You see, the moment the entire compensation is paid, Form K is entered. Story over. Now you cannot do anything about it. But you offered them 80%, and they took it.
So my submission would be my submission is that arbitrator has not held this and they are not in appeal. Arbitrator has not held this that there was no compensation. There is no determination of compensation. They are not in appeal and we are in appeal value. We are purely what is
the
arbitrator
has taken into consideration that Form K was not entered.
Form K in the context he has taken
Form K, the question of entering into Form K arises only when there is 100% satisfaction and 100% payment of compensation.
If I express section 8.
You read section 8. Does it say that Form K is to be entered into upon payment of 80%?
It says mode of payment, compensation. If you leadership, you kindly come to section 8. Section 8. Principles and methods of determining compensation. Very opinion, where any properties requisition or acquired under this act shall be paid compensation, the amount which shall be determined in the manner in accordance with the principles set out. The amount of compensation can be fixed by agreement. So I am not fixing the amount by agreement. That is Form K. Where no such agreement is reached, the central government shall appoint arbitrator. So this second clause they are invoking. Now our intervening facts that I have brought, and that is part of the record, that learned arbitrator holds that there is no Form K, there is no agreement for determining the compensation. Therefore, you ought to have appointed arbitrator. Our case in one line is that we offered the compensation determined in terms of the rule. We offered them, they have received without protest. 20%. This is my submission. This is my submission.
But you have not taken any steps in connection with entering into agreement.
No, I have that.
So what does that imply? That no agreement was reached, and therefore there was a need for appointment of an arbitrator.
There was no objection from there. I am reading act and rules together. So that is my submission, right? Ultimately, that what has to be decided is there. My submission is that there is no objection within 15 days, and that's what Honorable Apex Court says, that receiving offer without objection or otherwise. So, and there is no finding to that effect. An arbitrator only says that since we have not decided, now what will be the latches? There is no objection within 15 days, 16 long years sitting idle. There is no request representation to appoint arbitrator. There is no protest from their end to that we are receiving under protest. So where was the occasion for me to appoint an arbitrator for those who received without protest? Now in 91, 20 persons comes before the writ court, notification, and then expanding the scope to those persons who have received without protest. That is my case. There was no occasion for me to appoint arbitrator for those who had received without protest.
para 4 of the judgment you have said.
95. The question therefore is it?
Yes.
The question therefore is whether the appellant are liable to pay interest to the respondent for the delay in appointment of arbitrator. Section 8(1) of the Act emphasizes that where any property is requisitioned or acquired under this Act, there shall be paid compensation, the amount of which shall be determined in the manner and according to the principles set out thereunder. Manner laid down fixable by agreement determination by arbitrator, where no agreement can be reached. Section 9 of the Act enjoins payment.
No, you just read it very clearly.
Truly.
Right. Manner
Manner laid down are two.
One,
Fixation by agreement
fixation by
and
agreement.
two,
And
determination by arbitrator to be appointed by central government where no agreement can be reached. Section 9 of the Act enjoins payment of amount of compensation under the award subject to any rule made under the Act. The competent authority is therefore enjoined to pay the amount of compensation to the persons or person entitled thereto in such manner within a time may be specified in the Act. Under Rule 3, Rule 9, the competent authority, land acquisition officer, is enjoined as soon as may be practicable to communicate to each interested person an offer which is fair in his opinion of the amount of compensation payable to such person in respect of the acquired property. Under Section 5(1), when an offer is made to such person, he shall within 15 days of receipt of offer communicate in writing to the competent authority his acceptance or otherwise of the offer. If he accepts the offer, the competent authority should enter into an agreement with him on behalf of the central government in Form A. Clause 2 of Rule 5, Sub-Rule 5 is not material and hence omitted. Under Sub-Rule 6, if the person to whom an offer is made does not accept the offer or does not communicate within 15 days of the receipt of the offer in writing to the competent authority, his acceptance or otherwise the offer, the competent authority should.
Just a moment. If the person to whom an offer is made does not accept the offer or
does not
communicate within
15 days of the receipt of the offer, in writing to the competent authority, his acceptance or otherwise of the offer, the competent authority should, as soon as may be, submit to the central government a report setting forth the full fact of the case, particularly as regard to the nature and extent of the disagreement between himself on the one hand and the interested person on the other. And he should forward with the report all connected papers. The competent authority should at the same time deposit in court the amount offered to by him to the said person under Sub-Rule 3.
So therefore, if he does not accept the offer, like he does not physically take it, or does not communicate within 15 days of the receipt of the offer in writing that his acceptance or otherwise. So both the options are there. It is not a case that he has accepted the entire award as I see it. It is not a case that the claimants have accepted the entire award but they did not register any protest. It is a case where the claimant had accepted only 80% of the award without recording any protest, and ultimately no agreement was entered into, and the authorities, they did not do the needful to communicate to the central government as to why the agreement was not entered into and what steps are to be taken. And therefore the central government ultimately did not deposit the differential amount in the bank. This is the fact of these cases.
We have to see what is the offer first of all.
We have to see what is the offer, tell us what is the offer, and how much did they accept? Did they accept the entire amount or did they accept the partial amount? If they accepted the entire amount, right, then the situation is different. But if they have accepted only 80%, or maybe that you offered only 80%, we do not know. आप कितना लिए थे? पूरा लिए थे कि 80% लिए थे?
80% offer has to be seen.
Offer has to
So
be seen
the
certainly.
leadership, one indulgence.
No, we will see it simultaneously, don't worry.
One indulgence.
No,
to your,
that's-
I will not consume much time in leadership. I will be summing up. I want to just marshal out the facts while addressing the honorable court. So I am actually on document. I am literally handicapped as of now. So that
An
I know.
advocate in this
that-
court can never become handicapped so far as the records are concerned.
No,
I will
not
just-
for
I will
the
just-
court reason. Not for it is for
No,
my
not
reason.
for whatever reason. Let us see it. Let us see
Yes,
it.
yes.
Let us
Because I don't
examine
have
it.
the documents, so I am not able to assist in the manner which I was planning to assist. Because today itself I will prepare these whole documents. I have applied also for this certified copy. But this
I'm
is the
sure.
way.
I'm sure your response before the learned arbitrator must be there with you.
No, not
It is your response.
Yes, but
How did you respond before the
that
learned
document is
arbitrator?
not with us.
Okay, let us see. Maybe that those documents are not before us, but let us finish the reading of the award.
Yes, yes, that.
That is most
my
important.
intention
And
should not be
if
doubted.
they, no, we are not doubting anything. Please.
I am here to assist.
Never
you.
ever
My-
take it that.
once I
Never
was back-
ever take it like that.
My-
Let us see what is the award, what facts the learned arbitrator
Yes, yes,
has
yes.
written,
I
and if there is any mismatch, right? If there is any mismatch, suppose the arbitrator has written that only 80% was taken, but you say no, 100% was paid, then there may be many situations.
yes.
Then you can verify the records and find out that what was the awarded amount, what was the offered amount, and how much.
I
did
go
they
down. I go down.
accept.
Then I'm just
Because
continuing.
that will make a difference.
Yes,
A
I
lot of
agree.
difference. That how much amount was actually.
And what consequences? What now? This.
What
this,
consequences?
This,
Yes, consequences we will see.
This query I was not. I could not anticipate, which is a very valid query. That 20% if not given, what will be the
Consequence.
legal consequences of this?
Yes.
This I have not. So taking.
And you see, that is why the legislature being very conscious of
Yes,
the
yes, I
fact
understand. And
that
these
the
are-
person may just accept it, will not put a protest. You see, everybody is illiterate, right?
Then
So
these are-
saying that I am receiving it under protest, he will not even be in a position to write that he is receiving
Hold
under
on,
protest.
hold on. I
Therefore,
can understand.
the entire conduct of the parties is
Has to be looked at.
crystallized by an agreement, which is contemplated under the Act itself.
Ultimately, I can understand what is coming from my leadership. Should I
Let's
proceed
see
with-
the award. Let's see the award.
Yes, yes,
Kindly
that-
proceed with that.
Yes. So we are
We have para 5 we have completed.
Para
Para
six.
6 also we have completed.
para 7.
Para 7.
Therefore, by notification number so and so, issued by Home Department, Government of Jharkhand, the present arbitral tribunal was constituted. The gist of the order passed in this proceeding. Immediately upon receipt of the said notification dated 23 to 30 in the first sitting of the arbitral tribunal, wherein notices were issued to the respondents. On the next date, that is 2/4/30, the claimant land user appeared and filed their settlement of claim. Liberty was granted to them to file substitution petition. The district land acquisition officer was directed to furnish the record of the entire proceeding. On 13/5/13, the DLAO furnished some records and undertook to furnish further other records subsequently. On behalf of the land user, their heirs, 91 substitution petitions were filed. Claim regarding the acquisition of house, well, and trees were also filed with respect to the explanation of delay. The certificate issued by Mukhia were also filed. Might not be just highlighted when we come to the act by determining these 3 lines that I have just
Claims regarding acquisition.
house, trees, and other things. A composite reply to the claim petition and substitution petition was filed by the defense state officer hereinafter. It was inter alia contended by the DO that he is not aware of the fact mentioned in the substitution petition, and the same should be verified by the respondent to the deputy commissioner. It was further contended that legal representative sought to be substituted should also produce succession certificate. After hearing the parties, the claimant and users were directed to file Parivarik Satyasya Suchi Praman Patra issued from Mukhia of the villages, which were also verified by the respondent number 2. Ultimately, considering the entire circumstances, the substitution petitions were allowed, subject to objection, if any, by the respondent and or interested aggrieved person at appropriate stage. Then a petition was filed by the respondent number 1 to have the certificate issued by the Mukhiya in relation to substitution petition verified by the respondent before proceeding further. After hearing the parties, it was ordered that verification and the instant proceedings will continue simultaneously. Respondent number 2 was requested to move the Home Department for extension of time for pronouncing award, followed by reminder on 27/7/13 and 31/8/13. Then on 28/9/13, keeping in view the provision contained in Rule 10 of the RAIP rules and the said order of the Honorable Supreme Court dated so and so, as well as notification dated 23rd February 13, whereby the tribunal was constituted, the period of these proceedings was extended up to its conclusion with consent of the parties. Again on 22/3/14, on behalf of the respondent number 1, it was submitted that respondent number 2 should verify the list of the claimant and submit a report. It was mentioned herein that in spite of several opportunities, R2 did not furnish the verification report of the heirs of the original award. After considering the fact and circumstances of the case and the said order of the Honorable Supreme Court, it was ordered that neither it was necessary nor proper to delay the disposal of this case relating to the acquisition made in or about year 71 on ground of such verification. As the main question to be decided in is the quantum of compensation, and if it is enhanced, then only further amount would be required to be paid to the persons who are found entitled to by the competent authority in terms of the Rule 10(6) of the RAIP. It is also recorded that in spite of repeated orders, respondent number 2 did not produce copy of the notification dated 5/6/93, and therefore Mr. Day was allowed to file a copy of the notification dated 5/6 on affidavit, which was duly filed by the claimant. The same has also not been challenged by the respondent. It may be mentioned here that several persons filed petition for adding them as claimant in the proceeding, but after hearing the party, all such petitions were withdrawn or rejected as their name did not figure in the notification dated 5/6/19. However, on petition filed by Mr. Day, some landowner whose name appeared in the notification but who could not appear in the proceeding earlier were added as claimant after hearing the party. Mr. Day was also permitted to withdraw the claim of those landowners whose names were mentioned in the notification dated with liberty to them to approach appropriate authority. This may be taken whose name were not mentioned with the liberty to.
Right. That is a separate. Award is
So we are
confined to
confining
only
to only
660.
5/6/93.
No, 660.
660.
660. Those who were left out, they were, and their name was there
Not
in
there in
the
the
file.
notification.
So the case is confined to only those persons whose name is there in the notification dated 5/6/19. There is no doubt.
The hearing was concluded on 20. Then the final list of award whose awardees their heirs are appearing before us. Before this tribunal was filed for Lalganj up to serial 212, for Lalganj up to serial number 29 in relation to houses, for Sugunu up to serial 243, for Patanga up to serial 81, for Gari up to serial number 95, total 660. The hearing was concluded on 22/3/14. During the reading of file, the claimant filed an application on 9/7/14 indicating that there are mistakes in the award number in the notification dated 5/6/93. After hearing the party, mistakes were taken note and ultimately the hearing was concluded on 21/7/14. The claim of the claimant landowners in short is that they have they have not been paid compensation as per the law, and the same is required to be redressed and paid at a flat rate of 2 lakh per acre for land and also for houses with trees separately. On the other hand, the case of the respondent in short is that the compensation has been paid as per law and that landowners do not object at the time of receipt of the compensation, and the present arbitral proceeding is confined only to the landowner involved in the aforesaid 4-writ petition. The parties laid oral and documentary evidence in support of the case. The landowner claimant case and their argument are summarized as well. Nearly 2,000 acres of land for military purposes in 4 villages were acquired in 41 for requisition in the year 41, 42, and they have been acquired in the year 71 by the respondent. The compensation paid for acquisition was very low. It was not assessed as per law. Moreover, it was assessed and paid by categorizing the lands arbitrarily as nature and character of the land changed during the requisition period of 30 years. This may be taken note of, madam, that as we are addressing the compensation aspect. B. The land users had received payment made to the extent of 80% under protest and claimed proper compensation. In this the circumstances, authorities were obliged to appoint arbitrator, but it was not done in spite of repeated requests. Hence, litigation started in 1991. This may be also taken note of.
I'm just marking.
Ah.
You have marked B. You have
And
marked
D. Repeated request. What they say.
Right.
What is the material on it?
That's
Ultimately, Honorable Supreme Court of India, by its order dated 25/9/12, directed the state government to appoint arbitrator to decide the cases of all those who have lost their land pursuant to the notification. Short synopsis, detail of litigation has been narrated in the. I have placed that judgment order of the Honorable. The area in question was already developed in the year 1971. After requisition was done 30 years ago in the year 1941-42. This may be taken. Then, though the lands had its irrigation facilities, the nature and use thereof changed during the last 30 to 40 years, and the area became urbanized, and therefore the land could not be categorized and treated as agricultural land by the respondent. Yes, this may be also taken note of. The authorities did not take into consideration relevant matter while fixing compensation. The acquired lands have very high potentialities, having good irrigation facility, and being near adjacent to Zumar River and Swarnrekha River, and also National Highway NS30. A state pitch road has passed through village Lalganj and Hatanga meeting NH33 and 31. H and I. This may be taken note of because when it developed, because ultimately I determined compensation sometime in 1975. Even the order sheet of 19472 of DLAO Ranchi mentions that agricultural land of class near Ranchi Basti and town are being used for building purposes, and as such they have been treated as a single class of land for the purposes of valuation of land, and that valuation on basis of classification of land on basis of agriculture will not be applicable in this case, as these lands are near to Ranchi town and all the land form the same status since they are in occupation of military since 42-43. This may be taken note of. The land users are entitled to a flat rate of 2 lakh per acre for all kinds of land, rupees 1 lakh per house, rupees 10,000 per well and 500 per tree. There is a delay of about 40 years in appointing arbitrator in this case, and therefore the awardees, land users, are also entitled to solution at the rate of 30%, of interest at the rate of 9% to 15% per year. The land users have relied on several exhibits and judgments in support of their contention. Lastly, it has been submitted by the claimant that all facts detailed in the statement of claim, evidence document, exhibits are sufficient and they are completely dispel the defense version of the respondent, and the claimant are entitled to all reliefs as claimed, including litigation costs. Survey map of Paki Anchal is Exhibit 1, notice under 12(2) LA Act, certified copy of Khatiyan, certified copy of judgment of High Court, certified copy of judgment of High Court taken on 9/3/98, certified copy of judgment of LA case so and so, certified copy of same of 1963. This may be taken note of because somewhere this has been formed basis for computation of compensation. And the mechanism that arbitrator has adopted is 10% per year will be the enhancement of the rate. In reversion he has calculated.
This paragraph number?
I was placing this exhibit here.
Exhibit.
This 7 exhibit which is at Roman 7. List of documents, that is internal page
Yes.
9 I was placing.
Yes, yes. Roman 7.
So these are some of the sale deeds that they have produced. Is one of 63, then thereafter it is of 62, then certified copy of sale deed of 71, then photocopy of the order DLAO, Ranchi for 4 villages, then a photocopy of DLAO Ranchi for 4 villages. Then
He has drawn the calculation actually. The learned arbitrator has considered the various sale deeds spread over the years, and then he has deducted it from the current sale deeds, and then he has reached at the calculation.
No, not as such. I will just place it. What he has done in reverse and say like he has taken a deed of 80, suppose 85. So then he has reduced it by 10%. He has taken a deed of 62. So he has presumed that the land will escalate at the rate of 10% per year.
That is a fairly good estimate has been.
I will try to.
This is how they will put it.
So we take valid the circle rate that is state fixed for the purpose of registration, that never goes with 10%. If the circle rate today this year is
the compensation can never be referable to the circle rate.
That acquisition act, if we take clue, that acquisition act says that is the basis, and vicinity concept is also there, and that is from earlier also in 1894 act.
It is the market value of the property.
And vicinity, he says that a land situated 1 kilometer inside will have the same.
They say that it is adjoining to the highway.
That is when highway came.
When did it come?
So that is the person who is putting forward his case. Onus is on him to establish.
You have no idea when it
No, we computed. Our computation was there. They should have displayed solely there was a highway in 1971, and he has computed at agriculture.
It is everything is on there.
Onus mandate to establish. Once I come, that is the basic principle. My lord, we have learned from my lords that whatever is coming, burden shifts on them. If they come with a positive case for themselves, we have come, our order is under challenge. So we are justifying our order. Now we cannot come and say that this was the compensation. Highway was there. Evidence of witness number 1, 2, 3, 4. Respondent defense. The respondents have objected and challenged the claim of the claimants. The same is summarized as under. The respondents have resisted the claim of the land user in total. Claim on behalf of all land user awardee is not permissible in law, and claimant should furnish the exact and correct number of the awardees. The instant arbitration is confined in respect of 20 land users who had preferred the writ petition so and not in respect of the land users, all land users. And there is no direction of our Supreme Court to entertain the claims of other land users, and 20% cannot represent the other land users. The amount awarded and paid is as per law and was awarded as per the prevailing market price. The lands were acquired for defense purpose and in the area was undeveloped at the relevant time. The compensation was accepted without any protest, and after more than 40 years, the claimants cannot claim for higher amount. The correct position of land users as well as their legal representative may be verified by Deputy Commissioner, District Land Acquisition of Ranchi, because that was an onus said to us that you verify and give their details. There is no provision of under RAIP Act for payment of solution and interest. Lastly, it has been contended by the respondent that the award of compensation was proper and the same was as per the market value and was received without any objection thereon, and that the land users' claims is stale and they have failed to make out any case for enhancement as such resistant claim are liable to be dismissed. With document filed on our behalf. So notification pertaining to village Khatanga, valuation report, village Khatanga, award pertaining to village Khatanga, notification pertaining so and so, valuation report of village Gari, these are all awards so and so, all villages. Then award pertaining to Lalganj, we have produced. Then evidence of witness number 1, respondent number Navras, SDO, defense officer, evidence 2, and evidence of Sri Abhayanand, District Land Acquisition. Now issues. Whether the claims are maintainable. This is the first issue that has been found. then valid whether the instant arbitral proceeding is confined to 20 petitioner or to all land users as mentioned in the notification. And whether the award is now coming to finding.
Now, before we come to the
Yes,
findings,
you have mentioned.
let us see what the learned arbitrator has done. You come to page number, internal page 35.
35.
He has recorded a finding that only 80% was paid.
Yes.
That finding is there.
Yes. Yes.
I'll show you that finding.
Yes. Yes. I have
Para number 31.
31.
31.
32. Yes. Yes.
There is a finding about paid 80% payment.
Yes.
Correct?
Para 31.
31, last time. Further, there is nothing to show that the circumstances enumerated in Rule 5952A or B existed, justifying payment of only 80% of likely compensation. 31.
31 for last paragraph, just about 31.
Internal page
Yes.
32.
Now there is no agreement informed you. Further, there is nothing to show that circumstances enumerated in Rule 9.2 A1A or B existed, justifying payment of only 80% of likely compensation.
So there is a finding that there was a payment of only 80% at the initial time. So there is no question subject to what you have to say from the records. This is all subject to what you have to say from the records. You come to page number 35 and let us see what the learned arbitrator has done.
But the unitship is asking me to come down to page number
35. Internal page 35.
internal system. Yes.
Yes. This rate is subject matter of challenge. Award. Let us see the award.
Yes.
This rate 41,750 computation is under challenge by the way. Correct?
Yes. Compensation for land market value at time of acquisition 41,750.
So this is under challenge.
Yes.
You are questioning this also.
Yes.
Now you see, deduct the amount paid by the competent authority.
Yes.
Right?
Yes.
So what remains is 20%. Now he comes to component C. A minus B.
What remains 20% unitship? Actually, out of this.
Out
Yes,
of
yes,
this.
Yes. Yes. Correct.
Right. A minus B would be the amount
That is to be paid.
He takes 41,750 as the actual quantum of compensation, and then he deducts the amount already paid, whatever be the compensation.
Whatever be the
Right? It may not be just 20% of the entire compensation. It will be much more. It will be much more. Suppose the initial compensation was rupees 1,000.
Yes.
80% was
800
paid.
is deducted
800, only 800 will be deducted, whatever was
from
already
it. Yes.
paid.
Yes. Yes.
Then he adds solution to component C
Yes.
and not to the entire awarded amount. Solution is only to the compensation C, the amount which remained unpaid
Yes.
as per the awarded. Then E is blank. Then he adds simple interest 9% on component E. E would be the total amount.
Total amount.
Right. On component E from 1/1/1976 to 31/7/2014. Correct? And then he takes out the total. And further, he says that if it is not paid by 31/1/2015, the claimant will be entitled for simple interest at the rate of 15%
Per annum on amount of G. Got it? Yes.
on the amount of G.
Yes.
So there would be a component of interest. So this simple interest 9% will be
Up till the date of award and 15% after it.
After it.
After the time frame prescribed under it.
after the time frame prescribed.
Remember that.
So now this time frame being prescribed under the award, this amount has not been deposited anywhere, as I see. It is still lying with you. It is
Instruction
still,
is required from you.
no records will show.
No, this amount whether they have deposited is after award.
ये तो कहानी चल ही रहा है बहुत दिन से. तभी ना आप स्टे मांग रहे हैं. जब आपके स्टे पिटीशन में you are saying stay of the award.
So then it may be the
Had you deposited it in the court, the situation is different. It is just stay of the award. So you just wanted that you should not be depositing this amount. Stay petition फाइल हुआ है. और जब से मेरे पास आया तब से हम सोच रहे हैं इसको कैसे डिसाइड करें. ठीक
I can
है।
understand
So ये
very-
जो है
जी।
इनिशियल मार्केट वैल्यू कितना था, कितना फिक्स किया था इन्होंने?
6,000 something.
6,000 now get enhances to 41,750.
Sorry. 6,000 was also correct.
Page 60.
Page
16.
16.
Internal
5,800.
225 रुपया पर एकड़।
225 रुपये पर एकड़।
हाँ, प्रति रहती का लोएस्ट जो रेट है।
नहीं फिक्स कितना किए थे?
6,000
फ्लैट रेट फिक्स किया 41,000।
और इनिशियली फ्लैट रेट नहीं था क्या?
नहीं,
आप आइए पेज 16 में
और भी 4 विलेजेस का फ्लैट रेट था, लेकिन रेट है 8।
अच्छा, सब अलग अलग
वही बेसिस
yield of the land.
दैट वाज द बेसिस ऑफ कंप्यूटेशन।
सबका नेचर ऑफ लैंड अलग अलग था,
हाँ, तो उस
तो
हिसाब से
इसीलिए उसी हिसाब से
225
जैसे
नहीं ऊपर 6,000 रुपए भी तो है।
6 है, लेकिन झारखंड में
It ranges from 6,000 to
लेकिन
225.
झारखंड में लॉट से क्लास 1 और क्लास 2 मिलना बहुत मुश्किल है। यहाँ
उतना
मैक्सिमम
आपको आइडिया नहीं
I
है,
don't know,
झारखंड में हम
we don't
खेती
know.
नहीं करते, हमको कोई आइडिया नहीं।
हम एक 75 गए थे 225, तो वी यूज्ड टू हियर फ्रॉम आवर मदर दैट उस समय 40 रुपया था गोल्ड, तो 1,10,000। तो जो 225 भी हो गया तो इट विल कम टू अराउंड 7 लाख। उसमें तनख्वाह थी 400 रुपये 300 रुपये। वी कैन नॉट
The valuation of tree was assessed as rupees 26,724. 68 houses were provisionally assessed at rupees 1,36,000. 12 pakka and 15 kacha wells were assessed at rupees 30,000. This was the assessment.
for village log land. This whole lot of minor will find from Roman 3 or above. The village is indicated, then the details are given. Now the basis of computation, nowhere arbitrator has dedicated to the basis of the determination of this.
For 3 different villages.
Yes, it is approximately in the same range.
So the sale deeds which were available at that point of time were taken into consideration.
When the DLO fixed this.
DLO fixed
Yes,
the
yes,
rate, right? Does the arbitrator ignore those sale deeds,
yes.
or he considers it?
If I just take to the award.
Let us see. Let us
Yes.
see. Let us see how the computation has been done.
From para 11. Yeah, the para 10 would be relevant. Para 10, para 11.
This paradigm.
Just 1 minute. Thus, on perusal of exhibit 10, it is evident
Internal page.
internal page it will be 90.
Yes.
Thus, on perusal of exhibit 10, it is evident that irrelevant, contradictory and arbitrary consideration has been applied in fixing compensation amount of the lands of 4 villages. Now, this has not been dealt with. Now, what comes out from record? It is evident that various classes of lands were sold and
Just a moment. Now let us see this Sugna village. The court, the arbitrator here that it is irrelevant. For Sugnu village, the land was classified page number 18.
18, yes.
Some of the sale deeds were collected.
However, the same were ignored on the grounds that 2 sale deed pertained to mixed classes of land and hence were ignored as market value of land could not be derived from the sale. 2 sale deeds pertaining to Dhanwan lands, which is situated at 9 chain distance of the land under acquisition and are of period much prior to the publication of Form J. 3 sale deeds are of very small pieces of land and are of period much prior to the publication of Form J. 3 sale deeds are very small pieces of land and are of period much prior publication to Form J. 1 sale deed pertains to Dhanwan land and sold rupees 5968 per acre, and the same is near the land in question. land in village Dumardaga have also been acquired and their rates were approved by Deputy Commissioner Ranchi and hence the same was adopted in the case of village Sugun 2. The trees were valued so and houses were valued for rupees 1 lakh.
So these valuation has been mentioned in Exhibit 10.
Exhibit 10 deals with the compensation. Values
These-
also, yes.
These values.
Maybe.
So the arbitrator, at least one sale deed with respect to Dhan 1 lakh, that is the highest rate,
Yes, 569.
was available, which was sold at rupees 5,968 per acre, and the same was near to the land in question.
Yes,
So even if at best you can argue, we are just thinking,
yes.
right? So how does the learned arbitrator come to a finding that irrelevant consideration has been?
That is what I was submitting, that he jumps to a conclusion that it is contradictory because three aspects he has taken into consideration. If I place two mixed classes of land, there are two
No,
saving.
you forget about mixed classes. No, this is the compensation calculated by the exhibit 10.
10.
This is not the finding of the learned arbitrator.
It is not, but
This is the findings of the exhibit 10.
DLA.
DLA. He has referred to the various sales which were produced.
Yes, he has quoted it.
And out of them, he found that only one sale was there with respect to Dhan 1 land.
Yes, and that is 5968.
And then, even if that standard is taken uniformly to all the properties,
Yes,
then also it would not come to 49.
41,000 at that point of time.
At best,
Yes.
correct? At best, even if one sale deed is taken uniformly to all the lands,
Yes.
then also it will
It
not
cannot come to 41,000. That was the highest point that it reached, and therefore it fixed 6,000 for the advance one.
Yes.
59.
And then he reduced it accordingly. This is
Accordingly,
all
because
based
that
on
was-
formula. And
Yes, it's that Birsa Agricultural College campus. They
this is-
determine this productivity
Yes.
for 10 years or 7 and then divide it and then they come to a conclusion. That formula is given by them.
Right. So in order to give them maximum benefit,
Yes.
of whatever calculation the DLO had done,
Yes.
this was one of the sale deed which was available.
Available.
So uniformly it should have been 5,000 something.
5996.
Did they produce any sale deeds on their own for this particular period?
Yes, they have come up with 63, 64, one sale deed. We need to go through it. If by your leadership will kindly come to the exhibit that they have filed. That is internal page. I'm just pressing. Page 9, internal page 9. So, Roman 7, 8, 9. These are the three sale deeds they are bringing on before the London arbitrator.
Okay, now let us see what further findings on
Yes.
computation the learned arbitrator has given.
Yes, yes. So
From
we
the
will-
records.
From the records.
Para 11.
Yes.
Page number
Yes,
19.
from parallel, I'm just. From the record, it is evident that various classes of lands were sold at various prices. The rationale given by the concerned official in not considering the sale deed of the highest consideration is unjustified. The concerned officials have simply ignored the sale deeds by giving passing remarks that the lands are far off from the lands under acquisition. In case of acquisition of 2,000 acres of land, 36 chains cannot be considered to be too big distance. One chain makes 66 feet. That is so too big distance, more so when transfer of land in vicinity was quite scarce, possibly on account of requisition by Defence Department, and only few sale deeds were available. The concerned official did not consider that lands were acquisition as early in the year 1942-43, and since then they were under the possession of military for about 30 years and were developed due to establishment of cantonment. Further, the lands having been under military possession for 30 years prior to the acquisition makes the classification of land into various types redundant. All the four villages are contiguous to each other and are similar in potentiality. But on one hand, a flat rate of 5,882 per acre was fixed for village dairy on the ground that the agricultural land of any class near Basti and town were being used for building purpose, and as such they are to be treated as single class and cannot be classified for valuation on basis of agriculture, and that the lands were in occupation of military since 42-43 and are near to Ranchi town. But on the other hand, the valuation of other three villages, Lalganj, Sunu, Khatanga, was done by classifying the land as agricultural land. Further, so far as villages of Gari is concerned, some sale deeds of the year 1970 and 71 were not considered on the ground that there was big variance in the sale prices. But one of them, that is sale deed dated 2471, was made the basis of fixing flat rate of rupees 5882 per acre. Thus,
So therefore, as per the learned advocate, amongst the sale deeds, the highest price was ignored. Right?
yes, he
And-
says that there are the land acquisition officer was of the view that there is vast variance. Suppose a small chunk of land, this happens. That is
Let's take it this way, that 10 sale deeds are produced.
yes.
Which is the best one which was produced? Then also it will not go to 41.
It will not. I go down. It will not go. It cannot go 600%. This irrationality cannot
therefore,
be.
whatever be the best amongst them, the court, the learned arbitrator records that these particular sale deeds were ignored, wrongly ignored,
Wrongly.
by saying that by giving one or the other reason. So even if we give them the best value, then also the sale deed which was there before the land acquisition officer,
I go down there. I got it.
that
Should
should
have
be-
been taken.
that could have been taken.
Instead of substituting his own view, the
and,
material.
and entering into a backup. Let us see that, okay, the standard for Gari village, he says that 5882 was taken, and then he says that the same parameter was not used for other villages.
Classification
So,
of-
classification. Let us assume that whatever be the best rate for Gari village is given.
Yes.
Whatever be the best
So
rate.
what is that best?
What is that best rate is to be found.
Yes.
Because if there are because the learned arbitrator has perhaps gone into the fact that there is no particular kind of sale deed of that particular time it was produced.
No, he says because of the fact that he considers this fact that cantonment land comes so scarce, land was scarce, so much sale deeds may not have been executed.
So, but even one is sufficient.
Yes, one is sufficient for determination. I go down there. But I am just
You don't need
to go into hundreds of sale
not
deeds.
necessary.
Whatever evidence is there before the authority, or they could have brought something at that point of view. It has gone more than 700% by computation.
Continue reading this.
Yes.
Just I am constrained.
Thus, I am constrained to hold that there was no justifiable basis for fixing compensation, and the respondents have not assessed the sale and paid the proper market value of the land acquired under RAIPA. In the facts and circumstances of the case noted above, in my view, flat rates of land should have been taken for determining the compensation amount.
Which is the same as Gari.
In judgment, yes. In
Which is the
exhibit,
same as Gari because in Gari flat rate was.
5 flat was taken.
Okay. Again.
In judgment exhibit 5, also Honorable High Court affirmed the flat rate of 2000 per decimal of the land of village Utiatu and Tumagatu acquired for military purposes. As such, issue class C is answered in favor of the claimant and against respondent that awarded amount was not proper and was not as per the market value. The claimant land users have relied upon various documents in order to establish their claim. They have named a flat rate of 2 lakhs per acre of land, rupees 1 lakh per acre, rupees 10,000 per rail, 500 per tree. Apart, the respondents have totally denied the claim of the claimant. Before considering the facts and circumstances of the present case, the following legal position is to be kept in mind. The instant proceeding arising out of RAIPA, which is self-contained enactment. The principles and method of determining compensation is under section 8 of RAIPA, and careful reading of which it is evident that just compensation commensurate to the market value at the time of acquisition is required to be awarded. My lord, what was falling from your lord's side? what would have been just compensation is to be determined by this tribunal in the circumstances of this case. The following judgments are cited. Before that, if your leadership would like to have a look to section 8, because that will come into picture, because the arbitrator is taking into the fact that just reverse view. So just for a moment, if section 8, what is the mode of computation? A 3 may be C. Eight three just leadership will have paid. The compensation payable. Leadership is there in 18. The compensation payable for the acquisition of any property under section 7 shall be the price which the acquisition property would have faced in open market. Now that will be relevant. If it had remained in the same condition, this will be very pertinent 8.3. May I press it?
Yes. 8.2. I just
7
wrongly opened
the rules. Page 7.
Yes.
Just
7.
above 9. 3.
8.
Yes.
The compensation.
The compensation payable for acquisition of any property under section 7 shall be the price which the requisition property would have faced in open market, comma, if it had remained in the same condition as it was at the time of requisitioning and been sold on the date of acquisition. So he cannot take into consideration the cantonment, development and market and other things. Dhani 1 would have remained Dhani 1 in 71.
That's right. This is what I'm saying.
Yes, exactly, madam. I go down. And this is, it says, so it flat rate saying that it will be flat rate and Dhani 1, Dhani 2 will not go.
The development of the land into cantonment, etc., can certainly not be taken.
Not taken, and
because that is a subsequent development post.
And I paid for that. Requisition is it is a type of lease. I am paying them for that.
And there is no question of any compensation prior to the date of acquisition.
Acquisition.
Because the court cannot take into consideration that it was already with the defense services prior to the date of acquisition.
Yes, it cannot.
It cannot take into consideration.
I go down, madam. This is exactly what it is saying. So the finding of the court that it taking into consideration that cantonment has developed, so flat rate would have been taken, suffers from patent illegality. It would have been taken as if it was Dhani 1, Dhani 2, Dhani 3, whatever is the classification. Not that it was because of cantonment, I will take it as a developed area, and considering that background, I will now determine the compensation. And it is so clear, if it had remained in the same condition as it was at the time of requisition.
So therefore, any subsequent sale deed
will not be of no head.
is of no help.
That it has to come 71, what will be Dhani 1's rate, what will be
Anyways,
Dhani
let
2?
us see.
Yes, then by just proceed.
This observation was there in para number?
I was referring to 7 by
Para
17,
number?
17 internal page 21.
17.
Before considering the fact and circumstances of the present case, the following legal position is to be kept in mind. The instant proceeding arises out of RAIT Act, which is a self-contained enactment. The principles, method and determining compensation is under section 8 of RAIT Act, on careful reading of which it is evident that just compensation commensurate to the market value at the time of acquisition is required to be awarded.
At the time of acquisition.
Yes, now before that what has been dealt is that I pressed your leadership to have a look to it. Para 12. Have a kind look to it. Para 12. Rather 11 and 12 I am again reading from my notes.
Yes.
From record it is evident that various classes of lands were sold at various prices. The rationale given by the concerned official is not considering the sale deed of the highest consideration is unjustified. The concerned official have simply ignored the sale deeds by giving passing remarks that the land are far away from the land under the acquisition. In case of acquisition of nearly 2,000 acres, 36 trains cannot be considered to be a long distance. More so when transfer of land in the vicinity was quite scarce, possibly on the account of acquisition by the Defence Department, and only few sale deeds were available. The concerned official did not consider that lands were acquisition as early as in 1942-43, and since then they were under possession of military for about 30 years. and were developed due to the establishment. Now this is catch line, and were developed due to the establishment of cantonment. Further, the lands having been under military possession for nearly 30 years prior to the acquisition makes the classification of land into various types redundant. It is
Fair enough. Fair enough. The court said, the learned arbitrator says that it was already in the possession of the military for last 30 years. So there is no question of any classification.
It says that on the date of acquisition, whatever is the nature of the land will survive. If I just say
See, he says that on the date of acquisition, the nature of land itself had changed. Because it was already in possession of the military, it cannot be classified as Dhan 1 and Dhan 2.
But if
So
I read,
it was 30 years prior to the date of acquisition, the land was already in possession of the military. Right? So military has been developing whatever they have been doing with the property. Therefore, the market value on the date of acquisition was required to be taken.
and military development, Melody, if I just read for a moment.
Military development prior to acquisition. He is talking about military development prior to acquisition, not post acquisition.
Not post acquisition, I am saying on the date of acquisition.
Yes.
What is, so I just read it for my lords again, for my lords appreciation. The compensation payable for acquisition of any property under section 7 shall be the price which the requisition property would have faced in open market if it had remained in the same condition. Same
Yes,
means
sir.
requisition property of 41 remained in the same condition till 71. My activity, because I paid them 30 years, I paid the period which I utilized, I paid them for acquisition. There is a provision for payment there. So it says that you cannot go into character, that it has not developed, suppose.
You see, the point is that whatever be the status of the property on the date of acquisition is to be seen.
I humbly, probably there is somewhere, I
Yes,
am unable to,
I'm
I haven't looked to it.
Okay, the compensation payable.
Yes,
Read it,
yes.
please.
The compensation payable for acquisition of any property under section 7 shall be the price which the requisition property would have faced in open market, comma, if it had remained in the same condition as it was at the time of requisitioning and been sold on the date of acquisition. Means the character of the property will be taken on the date of requisition and sold on the point of acquisition. So Dhani 1 land in 41, it was not the case that it was a developed land. So on the date of acquisition, it remained Dhani, but it will fetch the price of 71, not of 41. On the date of acquisition, whatever will be Dhani 1's price, that will be the fetching price. He cannot go into the cantonment development. That is my humble submission for my consideration.
So, you see, at best, the authorities who have taken the various salients into consideration,
Yes.
they have at least referred to one or two salients of 1970 of the relevant point of time to fix the price of compensation. So, even if we take it as flat value,
Yes, yes, ma'am.
because with respect to one village, they have taken it as flat.
Flat. Yes, I go down, my lord,
So
because
if it is taken as flat value, then also the
We can-
maximum Dhan 1 rate
6,000
would be
6,000
available for each one of the.
6,000 or any salient of that point of time if refers higher value, that can be the best. So,
That's-
as our learned arbitrator says that some of the highest rate we have not taken into consideration
That's
without reflecting what was the highest rate in those.
okay. Now let us see how the learned arbitrator has come for the computation.
So, all lots of judgment has been then discussed.
Yes, all lots of judgment. We will see those judgments later.
Later.
Now let us see that what is the consideration.
Then internal page 34, 24. After the judgment, citations are there, witnesses are there.
Oral witnesses are there.
Then page 24 internal.
Oral witnesses may not be of much
Much
relevance.
importance
The
because-
reason is that the acquisition is of much prior in point of time. Those persons, most of them must have expired. And it is the,
And they say that there is also some of them which will go through the record that we have not visited the site or otherwise. But that will of not much importance because documentary evidence are there.
Let
I am
us
referring
see.
page 24, internal page 24.
internal page 24, yes. Let us read their evidence also. Let's just read
Evidence.
the
Evidence has not been
Your
described.
claimant has a para 18.
Para 18 will be.
Yes. Claimant has examined 4 witnesses.
Just need para 17, para 18.
Bottom to page 20.
Yes. I have all this. The claimant had examined 4 witnesses of the village in support of their case. Number 1, Virendra Mahto, Rajendra Gop, Jital Mahto and Sheikh Sarza. All witnesses have deposed on identical lines and amongst others have stated that the market price of the land in question was about rupees 2 lakh per acre in 71 due to their location and potentiality for development. Being semi-town area near to Ranchi town, for lands villages Putiatu which were acquired in 1986 and which were about 12 kilometers away from Ranchi. Rupees 2 lakh per acre was awarded by the arbitrator's area. Whereas the land in question is nearer to Ranchi town and there are rivers LS 33, SH number 7 Industry Engineering College, offices, railway stations nearby. Due to legal restrictions on purchase of land, very few sale deeds are available. Compensation was fixed wrongly, and the same was received and protest by the land user. Now, all this development which he is referring to, there is no evidence on the point when this came into existence. This medical college, engineering college, NH developments, road connectivity, potentiality of being developed. So he is referring 86. Say read and then this thing is discussed. Then coming to para 19, the respondents have also examined 3 witnesses. Witness number 1, Sri Arendas, his deposition, amongst other, is on the point that area was underdeveloped. There was no market, no school, college nearby. In cross-examination, he has admitted that he has not visited the aforesaid villages between 42 to 70 and has joined the present post about 6 months back. Evidence of witness number 2 on behalf of respondent so and so, SDO 3, defense state job so and so, he has deposed at identical lines in the same. In cross, he has admitted that NS 33 runs between Ranchi and near to 4 villages in question. Evidence of Sri Abhinandan so and so, he has deposed in identical lines at village so and so at rupees 1,56,000 per decimal for residential and so on 1,130 per decimal for plots on the side of the municipal road. He has further stated at para 10 4 villages to be developed as they are near Ranchi town, not anything about imposition at time of acquisition. The reference is of 1,130. In cross, he has admitted he has not visited the site between 42 to 70 and joined the present about 6 months. The respondents have relied on Exhibit 10, report of DLAO. It is already been held here in above that DLAO has absolutely failed in ascertaining the market value and as report of DLAO cannot be relied upon. Yes. Considering the pleading, the sale deeds of 27/7/78 and rectification deed of 27/7/78 relied on by respondent is altogether different area and hence the same cannot be looked into to determine the market value. Considering the pleadings of the parties, the entire material on record, and especially keeping in mind the following materials, I shall try to determine the market value. The claimant document which are not relied by this tribunal are Exhibit 4. Not relied, says.
Yes.
Certified copy of judgment of Honorable Court. The said exhibit is judgment of Honorable High Court in FA number so and so in relation to the land situated near railway station bus stand which were acquired under LA Act of 71 and for which compensation of rupees 250 per area was awarded. So he does not rely on this. So we are not averse to that. However, in view of the proximity of the land near railway station, I am not inclined to consider the said judgment for the purpose of calculation. Exhibit 6. Certified copy of judgment of LA Judge Ranchi on 9/5/12 in which lands were acquired under LA 2000 Act in 2006 for construction of overbridge over NS 33 at village Nampum and basis of the same deed and vicinity compensation of rupees 30,000 per decimal and additional compensation of 12%, solution of 30% and enhanced reward of 9% for 1 year and 15% per annum for rest year were allowed to be by the learned land acquisition judge. The lands were better in location and hence no much weightage can be given to the exhibit in present case. Exhibit 12. Judgment of 21/172 passed by Honorable Supreme Court so and so Srimati Triveni Devi, the same pertains to land situated in the main Ranchi Chaipasa road and Honorable Court fixed the rate of 1,35,000 per acres and also granted 5% severance, 15% solation and interest of 6%. The land in case was on main road and therefore is not relevant. However, following the relevant and relied in this case for ascertaining the market value, Exhibit 1 survey map Maki Anchal. From the same, it is evident that lands at Sugnu, Lalganj, Gari and Khadanga are contiguous, having road access with national highway. The land in questions are very near to town Ranchi. Certified copy of the judgment of High Court dated so and so. The said judgment is in relation to acquisition of RAIP Act of land situated in village Kuchiyatu and Tumbagatu in 86-87, acquired in 86-87, for the purpose of Project Army camp and situated about 10-12 kilometers from Ranchi town. Honorable High Court, while hearing the matter, affirmed the arbitrator's award, wherein flat rate of 2 lakh per acre was granted for the land required along with solution of 30% and 12% per year. The land under the present proceedings are similarly situated and ratio as laid down by the judgment applies to the instant case. The distance of present, we take a pause when it is of 86-87 and he never says what is the distance of these 4 villages from Ranchi. He says it is close to Ranchi. While discussing this judgment, he says 10 to 12 kilometers. The distance of the present villages under acquisition from Ranchi town is less than villages involved in this judgment. It transpires that flat rate of 2 lakh was paid pertaining to the acquisition of 86-87, about 15 years after the present acquisition. For arriving at approximate market value of the year 71, I am to adopt a reverse process, thereby making deduction of 10% per year from the said amount. So now he takes 10% reverse calculation. So when he comes down to for 71, it is 42,000.
You see Roman 3 also.
Yes, Roman 3. Yes, I'm coming to. Exhibit 7. Certified copy of sale deed of 19663 village Gari. This pertains to sale of land of 5 kattas in village Gari on 19663 at rate of 2,000 per acre, that is 24,000 per acre. This sale deed is one of the village involved in the present acquisition and is of prior date than the date of acquisition of the case and can be used for the purpose of determining the market value. Now when this is for 5 katta, this is the location has not been given, nature
Village
of
Gari.
village itself will not suffice value. The purposes like agricultural land, zone land, these are the various classifications value and the rates are there. The rate charts are there. And suppose if somebody comes forward, he needs something for himself, 2 katta, 3 katta inflated price. What is the basic average that was going in 71? One isolated piece of the sale deed cannot be looked into value. The general trend has to be seen. This sale deed is one of the, for determining the value of the land in 71, 10% average, so it comes to 64, 26,000, 1965, so and so, 1951,446. So my submission would be made that suppose individual may have a liking, emotional connect, he has gone for a purchase for his own understanding. Was this the general trend? Land, what is the once my lord, your ladyship will appreciate whenever there is a contemplation of any acquisition, there are certain purchase of land in piecemeal, 2 kattas, 5 kattas, we are there in one appeal. Will demonstrate a person from Lucknow comes down to Ranchi and purchase 2 decimals of land at a inflated price, agricultural land. So what was the general trend of the sale deed? Suppose 5 sale deed of 71 or to have been brought, average rationalization would have
So
been.
he took this sale deed of village Gari, and then he also enhanced the amount 10% each year
And come to
and came
51,000.
to 51,446.
Yes.
And then he says that by way of back calculation or by way of front calculation,
It will
it
come
comes to
around
be around 41,000
very comes. My submission is that isolated deed 71's deed was available. There was no occasion to fall back in 63's deed, and that to one isolated deed. Now, original sale deed of Lalganj is there, Mary? For determining
Yes.
71, I am inclined so and so, it comes to 71, 70,000. I deduct 20% towards development cost of the said land. As such, exhibit so and so 57,000. Now, exhibit 9, certified copy is sale deed on 2,471. This pertains to land, village Gari measuring 23 kattas, so and so, which was sold at rupees 10,000 on 2,471 at 27,000 per acre. This sale deed is one of the village involved in the acquisition and is here about date acquisition of this case and can be used for the purpose of determining market value. In the instant case, noted above, admittedly the properties were requisitioned in the year 41-42 by the defense, were acquired in 71-72. As such, property remained in possession of the defense department for more than 30 years and the same developed due to the establishment of cantonment area. It is not in dispute that the said properties are situated near to the capital city of Ranchi, the then town Ranchi. Further, it is also not in dispute that national highway and state highway is adjacent and water bodies in the form of river is also in the vicinity. From exhibit noticed above, appropriate valuation per acre comes to exhibit 5 so and so. In my view, average of these four valuations would be just and reasonable market price at the time of acquisition. I am fixing the rate at flat rate of type of land in exhibit 10. DLO himself recommended a flat rate for Ravi, which is contiguous to other villages. Moreover, in the High Court judgment, flat rate granted by arbitrator was approved. It has been already held that there was no justification for categorization of land for assessment, payment, and of compensation. This I will harp on 8.3 now.
While coming to while discussing these exhibits, the learned arbitrator has not referred to any of the sale deeds
71.
of 71 of DLO.
DLO. He has taken 1-2 sale deeds of say 5 katta. I purchase a chunk of land, say 5 katta. The valuation will be different. And nature of land, he says that I cannot go into various categorization of the land. Now Act says that you will have to take the status of the land, nature of the land as it existed on the date of requisition. You cannot go by the development which I did. I have paid you for 30 years. It is not that it was free of cost. I paid you. I developed. Now you will say that because you developed.
What did you pay for 30
That is
years?
requisition is there. That act itself contemplates rental is
Okay, rental is.
rental is. So these all things are there. Then this series of exhibit 11 he discuss of 85 Supreme Court on solution and interest. Then he puts us. If I just place that part also. On solution and interest, the claimant have drawn my attention to the judicial pronouncement referred to in above that 30% and interest of 9% per year and 15% of subsequent year. I am referring to page 31.
Yes, I know.
Have been granted where there was delay in appointment of arbitrator. The respondents have disputed the claim of solution and interest on the ground that there is no provision of payment of solution and interest under RAIPA. It has also been stated that for the fault on part of the claimant, no amount under the aforesaid heads could be granted in as much as for the first time arbitration was sought by and invoked in the year 1991 after 20 years. As per 8, compensation can be determined either by agreement or by arbitration. As per 9.3 RAIP rule, the competent authority is required to communicate such person interested and offer what is in opinion fair amount of compensation paid. Then as per rule 951, such person within 15 days of receipt of such order is required to reply in writing his acceptance otherwise of the offer. If the offer is accepted, an agreement in Form K is to be entered into as per 943 on account of payment of 80% of the amount likely to be assessed as compensation can be made when there is likely to be delay in assessment, where there is delay in reaching an agreement, and C, where it is clear that agreement cannot be reached. According to respondent, acquisition was made and compensation was paid as per procedure laid down, but they have brought nothing on record to show that 93 RIT rule was accompanied complied by. Therefore, there was occasion for the land user, no occasion for the land user to comply with 951. Is no agreement in Form K. Thus, there is nothing to show that circumstances enumerated in 942 existed justifying payment of only 80%. This I have argued, Your Lordship, subject to my Lord's appreciation. Here, as per Rule 953, it was clear that there was no agreement on the compensation. Thus, objection dispute to the amount of compensation existed from the very beginning. Now, this objection, this finding, I may be at laches, but objection from where the court has read probably 20% is not been, that may be, or Form K has not been entered.
No, 20% also. Because
20.
there is a finding that only 20%.
Yes, that objection existed.
In my opinion, 20%.
It says.
There is a finding that only 80% was.
That is there, but objection is a positive act. That is my point. Having failed in their duty, the respondent cannot contend that the land users moved the court in 1991 after about 20 years of acquisition. As noticed above, the Honorable Supreme Court inter alia observed that the land users were poor, illiterate, and scheduled tribal. In these circumstances, the land user cannot be penalized if they could not move the court only in the year 1991. Further, as per the order of the Honorable Court, all the land users under notification of so raised objection and who did not raise objection are to be treated equally.
What was the occasion for supplementary award?
Just coming. Running page 55. Running 100. Running 55. My lord is there.
Yes, yes, I know.
Just
I read it. It was only regarding the mode of payment,
more.
nothing more.
I stand corrected. I said that it was for 10%. Just so for laches it has been said. Now this poor illiterate travel, the Honorable Supreme Court only says that they have come in representative capacity. So you cannot go into those technicalities. They are poor.
एक का सिंगल वाला दिखाइए तो इनका एक केस में दो केस हम लोग बोले थे ना लीड केस आपका कौन सा है
203.
200 203 का जो आपको लैंड एक्विजिशन ऑफिसर ने जो अवार्ड दिया था वो कितना
एक्चुअली लॉर्डशिप अवार्ड बना नहीं था, सप्लीमेंट्री अवार्ड जब बना
मेन अवार्ड कब बना आखिर आपने 80% लिया है तो अवार्ड बनने के बाद ही लिया होगा ना
वो तो एग्जिबिट है लॉर्डशिप।
बताइए कौन सा एग्जिबिट कौन सा
The awards are there in exhibit part. We have produced now.
हम नोटिफिकेशन
awards have been exhibited
Yes, I will just place it from the award itself. Arbitrator award I place now. If you are sure to plan 20 internal page number 11, internal page 11, chapter 5 and Roman 11, 9 onwards. No, it has, yes.
this chart
Yes, no, I'm referring to the. I'm still in difficulty to
you are
refer.
referring to
I'm referring award that exhibit. It is marked.
Yes.
If I say award for pertaining to village Khatanga, it is R2/A3. So his case is from Katanga, Gadi, or when he are able to this particular case FA 200. Gari will be exhibit R2/B3.
पूरा विलेज का एक का वोट बना है।
हाँ अलग अलग अवार्ड बना है।
सबका अलग अलग बना होगा ना।
उसी में अवार्ड
अंडर एलए केस डिफरेंस है सबसे, चारों गांव का एलए केस अलग अलग हम अपने सर्विस में दिए हुए।
Only difficulty if one day I can go through that awards.
No, I will give you time. There is no problem.
I don't want to falter in the facts. I don't want to falter in the facts.
Appendix 2, Appendix 1 भी कोई था क्या?
Appendix 1 भी है। We have given notes में है।
गाड़ी का एलए केस नंबर है 7/70/71, सुगनू का है 6/70/71, लालगंज का है 5/70/71 और खटंगा का है 2/71/72। ये सारा एग्जिबिट है इनके तरफ से, पेज 11।
May I submit, my lord?
Yes.
Actually, in this is I am appealing to DC, my lord. Tomorrow will appear personally. My lord, in this case, what the my lord has asked question, that's why I have interrupted. In this case, the award was made under the Land Acquisition Act, not under RP. That is, my lord, the page 9 of the award. Our annexure is exhibit document exhibit 2. We have produced the award which was made, and that award was made under Land Acquisition Act, not under the RPA.
So how
They
does
are
that
not
make a
in-
difference? The principle is the same. Market value of the property has to be given.
Under the Land Acquisition Act, if you are acquiring a land, then the mode of challenging would be different.
Maybe it is different.
The
But the
award
point
not
is,
speak. The
it
arbitrator
is not
does
in
not speak.
dispute. It is not in dispute that the land was acquired under this
RAIP, that is.
RAIP. Otherwise, the very appointment of arbitrator would be void.
And they
Then
have
you go
not
and
said.
then you are representing whom? The claimants.
And they are not in a
Then the entire award has to go.
I am saying, just informing you.
No, it you see
my
the
lord.
format will not
I
make
am
any
not challenging,
difference.
I am not challenging, I am not making any submission, I am saying, my lord, I have asked the question, where is the award and who award?
So
Is the
whatever
annexure-
be the form, the principle of grant of compensation is by and large same, except solatium and those things are not there in the RAIP Act. But there are judgments that under certain circumstances, solatium and interest can be granted. That is a separate thing.
Covered by the judgment of Supreme Court.
Otherwise it is referable to market value of the land.
Yes, yes.
Right?
If this argument is brought again, then it will be a nullity.
Yes, then it will be a nullity.
Then the end of the matter.
So he is just informing us.
Yes, but
Maybe
that's
that in
not-
the format it is mentioned. That is a
No,
separate
what
thing.
actually has happened is competent authority under notification of 71 power is delegated to this endeavor.
That's it.
There is I am having that notification. I will present it.
That may not be
Relevant for the purpose.
relevant for the
And no, he has not
purpose.
essayed that part. We are on the merits of the award that has been delivered.
I just want to know from you that there are numerous settings
Yes, ma'am.
before the district land acquisition officer,
Yes, ma'am.
and he had taken the rate
Yes, ma'am.
with respect to one or the other city, and then he has taken that rate as Dhan 1 because the property was relating to Dhan 1 in that city, and then he had reduced the rate with respect to other categories of land. This is what he has done. So even if it is to be taken that flat rate is to be given,
Yes, ma'am.
then the best rate is to be given. Correct? Best rate would be Dhan 1. The learned arbitrator records.
Subject to challenge.
Certainly, that is subject to challenge. So, the learned arbitrator has recorded that the authority could not have taken at flat, was required to take it at flat rate because with respect to one of the village, flat rate was taken. Fair enough. With respect to Gari, I think flat rate was taken. But with respect to Gari also no illegality as such has been pointed out by the learned arbitrator. The learned arbitrator said,
giving that much of amount.
yes, by giving that much of amount, because as per the learned arbitrator, with respect to Gari, the approach was correct. Do you see any finding by the learned arbitrator that the approach with respect to Gari was
There
incorrect?
is no clear-cut finding, but arbitrator is right.
That's right. Arbitrator is right in saying that flat rate should have been taken. Let's take it.
It is one of the, my lord, said it is one of the category. There are other things has to be taken into consideration.
So,
Merely on basis of
so
sale.
merely, so therefore, the arbitrator is taking into consideration that there is a national highway, there is a state highway, all these things, but he is not taking into consideration as to when did they come up. Was because
we have a map. Map is of the there is showing that highway is crossing from my village. When my
map
turn
of
will
which
come, I
year?
will explain.
Map of which year?
Map not is of the year. I'm sorry.
The finding is that it is near to highway. When you come back to a word, it does not say the highway is crossing. It says it is near to highway, that is the point. And then school, college, medical college, engineering college.
And its map is made as per 1961 census.
61?
Yes,
As of year
Census.
1960, showing NH crossing through.
That was exhibited.
Yes,
Exhibit 1, exhibit 1.
That is exhibit 1. Showing the
The NH crossing through the villages. And that map is also saying that it's adjacent to the national.
What is the state? What is the
map of
state?
the Thana Ranchi, district Ranchi.
and the learned arbitrator has ignored the sale deeds which were available before the district land acquisition officer.
He had not ignored, I will say, Lord, he had not categorically dealt with the specific line.
See, there was a specific sale deed of a particular year of acquisition. The learned arbitrator is not dealing with that sale deed. Whatever material was there before the district land acquisition officer has not been dealt with by the learned arbitrator.
I will say what was the reason for that. In their deposition, in their cross-examination, they did not come up with anything that whatever value has been fixed is fixed by this sale deed and we are right. Deposition is entirely silent. What the arbitrator will do?
Exhibit 10 was there. Exhibit 10 was very much there. Exhibit 10 निकाल
Yes, sir.
Exhibit 10 निकाल लीजिए. Where is the discussion of finding with regard to exhibit 10 by the learned arbitrator?
Page, internal page 15. Internal page 5. 15. Internal page 15.
Internal page 15.
Just giving that deduced from the written, I mean, exactly. Para 10. Para 10. That's on perusal of exhibit 10.
This is the only discussion.
Yes. Yes. Actually, exhibit 10 was ignored.
Exhibit 10 मिल रहा है. नहीं.
My lord, small accommodation is given. My lord, this is 3-4 exhibits. I want a compilation. Schedule of 71 on the village and exhibit 10.
देखा exhibit 10 नहीं.
इसमें कोई से मिला किया
ये है तो serial number sequence.
सब है तो वहाँ पे जो लिखे हैं ना, जो सीडीड के ऊपर जिक्र है,
लेकिन जो रेट फिक्स किया गया उसको बेस नहीं किया गया एनी सेगमेंट को. सेकंड पेज से
लैंड एक्विजिशन ऑफिसर का पूरा रिकॉर्ड आया था ना, वो जरा देखिए उसी में होगा.
उन्हीं का ऑर्डर सीट है ये. डॉक्यूमेंट फाइल और यहाँ पर अपना इसमें सारा आ रहा है.
ये वापस तो लेकिन यही एग्जिबिट खोजना होगा. एग्जिबिट 10 वो लैंड एक्विजिशन ऑफिसर का जो रिकॉर्ड आया हुआ ना उसी में होगा ये exhibit.
yesterday we were inspecting, that was part of the
It is a part of the record.
yes.
Claimants
Yes,
exhibit.
he had a reason to go through it. All sales deeds have been referred to him. what I was proposing,
All the sales have been.
These have been discussed in that exhibit 10. There's a report by the deputy commissioner that discusses the report. That's part of exhibit 10.
so actually that was, I was making a small request, madam. Though I should not have made this, I should have been in more preparedness. But these 3-4 documents, exhibit 10 and 2-3 civilians of 71, which we relied upon, which was the basis of the award by the acquisition officer. I will place merit because this is a bulky report. We do not require to navigate in all these documents. What we are relying on. So we have also applied online for certified copy, but if my lord will allow, we can get the Xerox copy. He will be inspecting, we will be inspecting today itself. So
You see, we do not get the original copy here, so court cannot issue this.
no certified. So what I was proposing, subject to permission.
He is coming tomorrow. Let him come and
My lord,
address.
kindly
Address
see
it.
page 11. The
Sorry.
document which were not produced before the arbitrator, now they can't produce anything.
They are not
I see.
producing anything.
Kindly see page 11.
They are only referring to exhibit 10.
Exhibit 10, I am referring, Lord, I have the copy. I have the copy, my lord, if my lord say I
So our concern is that exhibit 10 considers a number of sale deeds, the area, everything has been mentioned in exhibit 10.
My lord, I am reading village Lalganj,
Okay.
DLO report. What DLO is saying, altogether only 4 sales could be found during the stretch of 3 years. These sales relating to serial number 13 are far away from the land under the land acquisition, the Lalganj. Then, my lord, the village Lalganj is contiguous to village Dadanga, Katanga. Land of this village have also been acquired for defense. My lord, we are saying so far as Gadi is concerned, my lord, this Katanga and my lord, no sale deed, they are saying.
No, what we are saying is that okay, the learned arbitrator has said that the learned DLO had wrongly discarded the sale deeds, right?
My submission is that, my lord, yellow report order sheet that is not the right sheet which were produced before the arbitrator. So the price fixed by them. There is no basis when the price was fixed. Otherwise, it should have been reflected from the detailed order sheet. He is saying there is no sale deed. Kindly see, my lord, one place he found sale deed, but he is saying that the rate is suppressed, it cannot be treated as a valid sale. Here the report is something else, and for the arbitrator, we have activated in the report, the official report. In report, it is the reliable document. And after that, when the arbitration proceeding is going on, you come up with some sale deed.
No, they are not coming up with any sale deed. You just
Otherwise,
see.
it should have been reflected in the
Is this discussion of the learned arbitrator with respect to each of the villages an error of record? Just tell us.
That is now from the DLA report.
That's right. For each of the villages, DLA is from the DLA report, right? For Khatanga village, the arbitrator says that 2 sale deeds of the year 1970 related to Tar 2 land transferred at the rate of rupees 1,000 and 1190.48 acres.
Yes, sir.
Right? The same are 38 chains away from the land under acquisition. And 1 sale deed of 1970 is of Dhan 2, which has been transferred at the rate of rupees 4,333.30 per acre, and the same is 36 chains away from the land of acquisition. Now then, land in village Dumadaka have been acquired and their rate was approved by the deputy commissioner and the rates has been mentioned. Right? So, the DLO has referred to the sale deeds and has not taken the best sale deed which was available. This has been criticized by the learned arbitrator. And at the same time, the sale date of that particular year was not exhibited by any of the parties before the learned arbitrator. So under such circumstances, the sale date which has been referred to in the DLO report, that particular rate could have been fixed at flat rate. Whatever you choose is the best sale date which was produced before the DLO.
I'm sorry, Lord, I may be not, Lord. In DLO report, there is no mention of any sale date.
So I just want to know from you the findings of the learned arbitrator in page number
Yes,
16,
yes.
17 and 18. Is it suffering from some error of record?
No, these sale dates should not have been considered by the arbitrator because these sale dates were produced during the course of arbitration. When the lands were acquired, they have to justify under what basis this rate has been fixed. That is the settled law.
Do you want to say that the DLO report did not refer to any sale date?
That's why I am rating. I am rating Miller. Exhibit 10.
DLO report is exhibit 10.
Yes, Miller.
कहाँ है?
Report is
ये
order
तुमसे
sheet.
मेरा record निकालो.
It's the order sheet. I am sorry, Miller. I correct myself.
Order sheet is not the DLO report.
It's the order
So it
sheet.
is different.
ये नहीं चाहिए, order sheet से कोई चलेगा. उनका DLO का report पूरा exhibit होके आया था ना, इनके पास इन्होंने मंगाया था DLO report.
It's the order sheet of DL.
That is the order sheet of the DL.
नहीं नहीं, हम अपने record से exhibit 10 देखेंगे ना, आपका document से exhibit 10 नहीं देख
Arbitrator had
सकते.
called for the report. आपने पूरा report दिया था. Paragraph 9 may be seen minute of the award itself it says. The award was prepared on basis of the reports of DLA. Paragraph 9 of the award says the award was prepared on basis of the reports of DLA district level. Exhibit 10, such report shows as follows. The lands were classified in various types while assessing. Some sale deeds were collected but they were ignored on the ground that these sale deeds pertain to the land. I am referring to paragraph 9 of the award. It deals with it. And if it is error of record, then it has to be.
नहीं मिल रहा है. Exhibit 10 है ही नहीं. और बाकी सब exhibit है कि वो भी नहीं. Exhibit 9 दिखाइए कहाँ. DLO का record जो आया है.
You can get the scanned copy of the.
कहाँ से देंगे आप इसमें?
We can scan it from our the court notes.
आप क्या scan करेंगे?
What exhibits, which important exhibit have. Though I have calls from the state officer. For keeping this number.
गोलाई जी को जरा बुलाएंगे.
Yes, it no problem. Schedule of 2471.
Yes. It takes note of what?
Schedule of 2471.
Which one? Which DLO? You have got a copy of the DLO report?
It is exhibit 9. 2470 is exhibit 9.
Exhibit 9 is dated.
2471.
The learned court has rejected that exhibit.
Yes, he goes back to 63, schedule of 5.
Does he reject 71 CLD?
He does not. That is certified. This pertains, yes, it is accepted. It is accepted. It is not rejected.
Where is that acceptance?
Page 29. It is on page 29.
This is one of the accepted documents.
This was a produced document. We are relying on defending our DLA reports. It is the claimant who came forward with 2471 DT.
That's it. Exhibit
9.
9. And if this exhibit is taken into consideration, what would be the rate?
So he has computed for 27 fertile acres, then he comes to a finding of DT. Then he refers to it that pursuant to ceded of land of Gully of 23 kathas, which was sold for rupees 10,000 on 2471 at rupees 27,000 per acre.
You see, the learned arbitrator records that all the lands are contiguous. He records a finding.
Yes, yes.
All the lands are contiguous. Flat rate should have been taken. And arbitrator himself has taken flat rate for all the footages. Correct? Now the point is that when he has amongst these contiguous land, when he has one of the sale deeds, that is exhibit 9, relating to the exact period and he accepts it also, then under such circumstances, where was the requirement of referring to any other sale deed of the year 62, of the year 84 to have a back calculation?
And so far as his
The
decision is
question of back calculation or front calculation comes only when there is no evidence.
true.
When there is an evidence with respect to a particular year and the learned arbitrator accepts that, then why should he go for back
Any further
calculation
calculation.
or front?
I go down.
And so far as whatever he is saying, that DLO report, although that report is there, but those sale deeds which were considered by DLO were not exhibited before the learned arbitrator. You should have exhibited those sale deeds. We will not, once the quantum of compensation is under challenge, whatever has been mentioned in DLO report cannot be taken as a gospel truth. If the DLO is referring to 5 sale deeds, then those 5 sale deeds should have been exhibited at your end. Those are not exhibited. We have one sale deed, that is exhibit 9, which is for rupees 27,000 per acre. The arbitrator accepts it. If once he accepts this,
And that is the document of claimant.
that is a document of claimant. Whatever, I do not know whomsoever has
He has
produced it.
produced it, so he
Right.
cannot resign from that.
Once he accepts that particular rate, where was the occasion for the learned arbitrator to refer to any other
Any
sale
other
deed?
document.
Any other document not relating to this period. If there are 10 sale deeds relating to 71, he can take an average, right? But if there is one sale deed of 71 and he relies upon that, then under such circumstances there was no occasion for him to go to the sale deed of 1962 and make a calculation. And then there was no occasion for him to refer to exhibit 5, exhibit 7. They are all not relating to the period in question. So at best, the evidence, on the basis of the evidence which has been accepted by the learned arbitrator, the rate ought to have been confined to exhibit 9.
If it is taken
At
to be
best.
contiguous.
It has to be taken.
Because I will be
It is one chunk. We are not, you see, I am very, very vocal on what I think.
No, that's
Right.
I understand.
So, after so many years, at best we can take it as contiguous and then fix it at exhibit 9.
My submission still would be valid while defending my client that it is not contiguous because state was with the rate chart of Dhani 1, Dhani 2 and Act says
Rate chart is of no use. What rate chart are you talking about?
Dhani 1 land
Where
is
is the
so the
rate
report
chart?
has to be
Circle rate is not the criteria. You have to produce the sale deed. Did you produce any sale deed of that particular area before the learned arbitrator? No. If the sale deed for a particular village is produced, so that particular village is to be adopted, and if the sale deed of another village is not produced, which has also been acquired, then the sale deed of the adjoining village can be taken into consideration. What's the big deal about it? If you were so conscious that the rate chart is to be accepted, then whatever sales were referred to in the rate chart, you should have exhibited. Where is that exhibit? No.
Give.
I think there is a judgment also to that effect. That merely because in the rate chart some sale lead has been referred to, that does not mean that that sale lead, that rate, that particular document will be taken as gospel truth unless the sale lead is produced. Because not only the sale lead, but also the area, the placement, everything matters when it comes to compensation
In terms of age.
in terms of rate. So, if that particular document was taken to be gospel truth, what was the big idea of arbitration?
No, that I don't. That I will never argue.
You have not exhibited those documents.
Let me once visit the report.
You see, let us see exhibit. Just a moment. Let us see each one of them.
Yes.
Exhibit 1 is a map.
Yes.
Fair enough. Now, exhibit 5 is a certified copy of judgment of High Court dated this. This was acquired in 86-87.
Yes. That is not of
Right? Okay. Now, with this, a reverse calculation has been done.
Yes.
So, this is, I don't think, of much use. Now, exhibit 7, this is sale deed of 63.
Not of use. because
Not
it
of
says
use.
of the
Exhibit 8 is sale deed of 62, not of use. Exhibit 9 is the sale deed of the particular period, right? And then these are the things. So only exhibit 9 was enough. Do you get this, counsel? Once there is one acceptable evidence with respect to the area and with respect to the date of acquisition, then under such circumstances, there was no occasion for the learned arbitrator to refer to other periods and then do back calculation and front calculation and then take an average. The question of back calculation and front calculation arises only when there is no evidence with respect to the area and the date of acquisition. One evidence is more than enough. You don't need more than that. You address us on that. You just come. Because we can take it, you are muted perhaps, I can't hear you.
Wait, I'm sorry.
So, think over it. One evidence is enough.
I propose the judgment will not be merely one said. Many evidence that before the arbitrator.
No, you see, just tell us one. The arbitrator has accepted it
Yes.
by citing reasons, right? Acceptance of this particular evidence is not under challenge. Once the acceptance of this particular evidence is not under challenge, then under such circumstances, this is enough.
And if your leadership permits me, then there it is their document. How can they back out of it?
It is your document. You wanted this. You have exhibited this.
It is exhibited by us.
It is exhibited by you. We will take your exhibit as the standard.
Admission section 50.
We have other submissions.
Not required, no. We will
I
see
will
that.
satisfy me, not
Yes. Come tomorrow, we'll see that.
Ultimately,
See,
the
we
final
are-
will
One
not
accommodation. Tomorrow he may come and address you.
satisfy
Yes.
me, Lord, the
Because I am
arbitrator
trying to-
jurisdiction can take
What all
other
possible best
evidence.
assistance I can provide.
There is one judgment I have seen in land acquisition magazine.
I will come with that.
That DLO report is not by itself an evidence. DLO report, if it is based on certain sales, those sales are required to be exhibited.
I will also like to try
हम
to get
यहाँ
it.
पर आपको ना एडवाइजर है ना हम आपके
I
लॉ
will
रिसर्चर हैं.
try to
Okay.
get it. I said so. I will try to get it. I am not saying that you will.
10:30 yes. बस हम थोड़ा माइंड मेकअप किए हैं. अब इस माइंड
तो
को
देखिए,
हटाने के
हम
लिए
आपको-
आपको थोड़ा मेहनत करना पड़ेगा. Both sides.
कल ये एड्रेस कर लें उसके एक दिन
ये
का
जो
exam
बैक
है।
कैलकुलेशन एंड फ्रंट कैलकुलेशन किस फॉर्मूला से होता है, कब होता है,
नहीं ये कंजक्शंस पे है। बाटली बॉय में कुछ दिया गया था इस तरह से वो आर्बिट्रेशन है।
बाटली।
चलिए
There was no concept of minimum rate money. So everybody purchase it available the rate to save the stamp duty.
We are not concerned. You exhibited a document.
It is well.
We accept it. बस आपने कहा हमने माना. अब आप बोलिए अब आपको क्या बोलना है? ठीक है, ये बाकी एक्सरसाइज appears to be unnecessary.
There is a fair for calculation of the fair actually.
फेयर
It was
आपने जो मांगा हमने आपको दे दिया। आपने एक सैलरी प्रोड्यूस किया, आपने आर्बिट्रेरीली नहीं मांगा, आपने एक सैलरी प्रोड्यूस किया कि भाई मेरा ये डेट 71 का सैलरी विद रिस्पेक्ट टू कर,
And that is the demand of the act.
हो गया, बात खत्म, फुल स्टॉप।
But आप थोड़ा सा रिपोर्ट पे I will address tomorrow, let him address. I will find to
गोराई जी, एक जजमेंट हम लोग लैंड एक्विजिशन वाला में जो हम लोग डिसाइड किए उसमें हम लोग एक जजमेंट साइटेड था कि जो रिपोर्ट है वो अपने आप में एविडेंस नहीं होता है। If it is referring to salary, the salary are required to be exhibited. और ये सारा रिकॉर्ड में एग्जिबिट 10 पूछिए कि एग्जिबिट 10 के साथ क्या है, मतलब वो रिकॉर्ड आया था डीएलओ के डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर का रिकॉर्ड में जो अवार्ड है उसी से हमको लगता है कि एग्जिबिट 10 जहाँ अवार्ड सब एग्जिबिट हुआ है ना उसी के आसपास में।
he is telling that left record is there. If my leadership permits, then you can flag it.
This one? तो मेरे पास रखा हुआ है सर।
हाँ, उसमें he is taking your permission if you can flag it.
हाँ,
Leadership से. Exhibit exhibit, there is exhibit 10. Good night.
हाँ इसमें सब जगह खोज में इसमें कुछ
He had visited. So, और हम लोग को भी एक एक कॉपी मिल जाता है।
कॉपी नहीं मिलती।
इसका फोटो तो ले सकते हैं, इजाजत दीजिए तो फोटो ले लो।
यहाँ पे हमने स्कैन कर लेंगे उसको।
Only for marshalling the facts. More or less 90% my lord has taken note of the facts. If there is anything can emerge out from the DLAO report,
ये ऑर्डर शीट क्या बोल रहे हैं ना, ऑर्डर शीट में ये exhibit 10
उसका issues नहीं। He said that the DC reports those who are part of the
Tumbaktu
There are two judge villages they have brought.
तुम्बाकू का क्या रेट फिक्स हुआ था?
वही रेट इसमें भी दिया गया है।
ये कुटियाटू का क्या रेट फिक्स हुआ था?
वही जो रेट इसमें दिया गया है।
आप कुटियाटू का रेट बताइए ना, जो ऑर्डर से चल रहा है अवार्ड से
उसी
20,000।
ने डीएलओ ने क्या दिया था रेट?
जो रेट उसमें फिक्स है वही रेट दिया।
आप बताइए ना, डीएलओ ने क्या रेट दिया? डीएलओ का क्या रेट था पर एकड़? कुटियाटू का
सिर्फ 6,000 रुपया भागमन हम इसको पढ़ देते हैं नोट्स।
6,000 रुपए पर डिसमिल।
एक मिनट इसको पढ़ देते हैं।
Serial number 4 let.
अरे भाई रेट बताइए ना, 1 एकड़ का कितना रेट दिया?
6,000 रुपया पर एकड़ धान हुआ। इसको पढ़ने से पता क्लियर हो जाएगा नोट्स।
Serial number 4 relates to the sale of mixed classes of land under acquisition. As such, no sale will help us in sale figures for the consecutive 3 years were collected to assess the valuation of the land under acquisition. Altogether, only 4 sales could be found during the stretch of 3 years. There, these sales relating to
किस केस में आपने कितना रिसीव किया है, इसका कोई डिटेल है आपके पास?
जमीन कितना इन्वॉल्व है इसमें, किस
जमीन कितना इन्वॉल्व है, कितना पेमेंट रिसीव किया है, इसका कोई डिटेल है आपके पास?
इसी ऑर्डर शीट में है नोट्स।
किस
रिसीव
order
करने
में?
का नहीं, कितना रुपया बना है इसमें।
कितना लिया है उसमें?
तो चिंता रखो।
इसको देख लें।
Yes. Will to so matter of tomorrow minutes.
हाँ यस।
You would like to go through visit for the
हाँ हाँ ये।
So we are narrowing down the issue number 1, exhibit 9, solation, interest. So these are the areas now I will be in rebuttal because of the principle of 83 and 9 I have.
रेट पे आपको और कुछ बोलना है इसके अलावा?
रेट पे हम थोड़ा सा हम देख लेंगे ना।
आप देख सकते हैं। DLO का दो पॉइंट इमर्ज हो रहा है।
Yes.
DLO का रिपोर्ट,
Yes.
but without exhibiting the sale deeds
And what
mentioned
exhibit
there.
we have brought before the arbitrator.
वो तो दिख ही रहा है ना।
नहीं पढ़ हमारे पास।
हाँ। तो वो जो अवार्ड में है वही exhibits है। इसके अलावा कोई exhibits नहीं।
And it cannot be said that I cannot bring the document before arbitrator because that is a lease.
No,
One
you
part-
can bring the document
Yes.
before arbiter. लेकिन जो आप लाए हैं उसी पे
उसी
चलेगा
पे
ना।
I cannot improvise the.
तो you have not brought the earlier sale deeds जो DLO report
I
में।
will confine valid strictly to the record. For sure.
ठीक।
Whatever little law I know.
और थोड़ा नोट बनाइए, दोनों तीनों जने
हम-
मिलकर काम करिए, जो जो बहस हुआ है इस पे नोट बनाइए, ठीक है? इसको हम CA भी नहीं करेंगे, हम बता दे रहे हैं।
That we know.
वो हम नहीं करेंगे, हम लिखाएंगे कोर्ट में, इसीलिए अपना नोट बनाइए, जो जो नोट में लिखेंगे वो सब लिखाएंगे, बाकी हम लोग सारा रिकॉर्ड देख ही लेंगे।
तो एक आध दिन का इंटेलिजेंस मिलेगा कल के बाद।
कल के बाद एक परसों का भी है।
परसों मेरा एक पार्ट है, फ्राइडे को
मतलब we will start from
my submission is पार्ट मेरा बहुत 22 का मैटर है, it will prolong. परसों के लिए नहीं, tomorrow I know this is
कोई बात नहीं, फ्राइडे को कर देंगे।
फ्राइडे कर लेंगे।
here just return back.
He will join virtually.
ऐसा नहीं होगा ना,
Okay, he will join us.
ऐसा नहीं होगा।
We will begin our argument tomorrow.
Grateful.
और अपना सबका अपीयरेंस दे देंगे प्लीज, इनका ऑनलाइन दे देंगे। आपका शुभ नाम क्या है?
Anand Miller.
मिस्टर आनंद का
Now,
भी दे देंगे।
but senior is also appearing in my grade, but he is stuck in some matter in some.
Who is your senior?
Not my senior, but one of senior advocate, my colleague, is also appearing.
Who is appearing? क्या नाम?
Santosh Kumar Tripathi.
He has not logged in.
Because he is
He is not logged in, तो उनके अपीयरेंस को नहीं रिकॉर्ड करेंगे। So he will be coming tomorrow.
He can also come.
These proceedings are all recorded. You can ask him to see this.
Yes, I know, because we have to, number of times we have seen in YouTube.
आप ही के लिए है, सीनियर्स के लिए, कि देख लें वो क्या क्या बहस हुआ है, मैंने क्या क्या बोला, ठीक है? Post this case for the matter has remained inconclusive on account of paucity of time. Post this case for further hearing tomorrow at 10 a.m.
Not one request, my lord. Tomorrow let them complete first.
They are already completed. हमको जितना सुनना था हम सुन लिए। सोलेशियम का देखिए, अभी क्वांटम पे बहस सुन रहे हैं। सोलेशियम और जो इंटरेस्ट वाला पोर्शन है वो हम इनका अलग से सुनेंगे और आपको अलग से रिस्पॉन्ड करेंगे। इशू वाइज सुन लेते हैं पहले हम लोग जो रेट फिक्स हुआ है इस पे, क्योंकि इन्होंने रेट को भी डिसाइड चैलेंज किया है ना, दे आर चैलेंज द रेट आल्सो। रेट पे हम लोग सुनते हैं आपको, ठीक है। उसके बाद सॉल्यूशन, आपको कितना टाइम लगेगा? सॉल्यूशन इंटरेस्ट पे तो आप कर ही दिए, आपको कितना बचना है?
थोड़ा
अच्छा ठीक है, let them conclude tomorrow.
आप सिस्टम को इतना नहीं
एक घंटा लगेगा आपको, आई एज्यूम सो।
जरा से हमें एग्जिबिट यदि प्लेस करना पड़ गया थोड़ा टाइम लगेगा।
ठीक, कोई बात, इनको कंक्लूड कर देते हैं, लेकिन नोट बनाइए साहब।
वीकली ऑपरेशन
हाँ श्योर, इसमें कोई विशेष लिखे नहीं। चलो, इसका काम करना है, थोड़ा सा एग्जिबिट देखिए। We'll have a discussion in the evening. अच्छा एक सेकंड, एक सेकंड, आपके केस का मैंने डिक्टेशन दे दिया है। The appeal is allowed. By day after tomorrow it will be uploaded. Who is there counsel for the other side? क्योंकि मुझे तो सिर्फ फाइंडिंग ही लिखाना था ना, आप लोग का सारा डिस्कशंस मैंने लिखाया हुआ है।
I'm for the other side.
I allow the appeal. You are for the tenant?
Yes, sir.
He is for the landlord?